Mr. President, dear colleagues, dear professors, bonjour à tous. But I will speak in English. I don't know how much the people in the room like films. By following on from some excellent Hungarian Oscar successes, allow me to introduce my short presentation with a film example. The award of the South Sun winning Best Foreign Film in 2016 was not the first Hungarian success. In 1982, Mephisto, directed by István Szabó, also received this recognition. Another film by István Szabó was nominated for an Oscar, Colonel Redl, about the life of Alfred Redl, the son of the Rutterian railway family, who became the Austro-Hungarian Empire's counterintelligence chief just before the outbreak of the First World War. The film shows how Redl denies his family, his friends, and ultimately himself only to abandon this Rutterian identity and become a subject of the Kaiser, the emperor, losing all sense of self-discretion. In a case scene of the film, the desperate word of the Czech soldier who dies a few minutes later in a duel, "I can stand this double life," illustrate the monarchy's difficult relationship with the people who lived within it and how identity played a decisive role in a completely different historical period. Colonel Redl could not cope with the dual identity. Just as in Austro-Hungarian monarchy, the question of identities and the mixing of identities can arise today also. I am both Hungarian and European, today in the European Union as well. My Hungarian identity is born with me, defined by my parents, my education, my environment, my friend. It is European in origin, and its significance is primary in relation to other continents. If I go to China, everybody can say, you came from Europe. But identity is not just about the individual. Identity can also be examined in the context of the cooperation between European countries and European integration. This brings us to the question of the relationship between the member states and the European Union. This relationship can be examined from many points of view, but for my part, as a public lawyer interested in European processes and as departing the MEP, I am primarily interested in the relationship between the law of the member states and law of the European Union. I know, of course, that politics and law are closely linked, so European politics is also expressed through the language of law. The existence of the European Union is an interesting question. In recent years, especially since the fall of the Constitutional Treaty and the various and growing crises, economic, COVID, Brexit, war, and so on, the literature has paid increasing attention to these issues. A few years ago, in the run-up to the Brexit, Joseph Weiler, in a respected European journal, gave his editorial foreword the simple title, "Integration Through Fear." This says a lot about why even the most dedicated European lawyers have begun to research and analyze, especially in recent years, the question of what is the raison d'être of the Union. It is precisely in her works, the Europe's raison d'être, the Guy and the Bursa, who cannot be accused of Euroscepticism by even the most daring, writes that the European Union has not developed a comprehensive democratic process, a strong collective identity, or a political unity. In its present state, it is far from deriving its legitimacy primarily from the traditional processes typically of constitutional democracies. As will be stressed later, as many on the subject, including the Bursa, have remained as the EU today is nothing more than a collection of independent states with different histories, cultures, languages, and identities. If there is a European specificity, it is that it is defined by fault lines between countries on the old continent. The different head of state and prime ministers are looking for compromises at European level, but I would like to focus on the identity of today. And what exactly is the identity of these member states? I have been concerned with this issue, and in particular the concept of constitutional identity for some time. The question of constitutional identity is only relevant in the context of European integration, namely whether a country has an identity linked to its own values, historical or political tradition, institutional system, which is considered secured and which integration cannot violate. The relevance of the question is undisputed since the European Union creates law in more and more areas and asserts the competence for itself. I can testify to this as a retiring member of the European Parliament. When we talk about the constitutional identity, it is useful to go back to the opinion of Advocate General Maduro in the Michaniki case. According to Maduro, national and constitutional identity are closely related concepts. As he writes, respect for the constitutional identity of the member states is one of the obligations of the European Union. It serves to preserve the political existence of states, but respect for constitutional identity cannot be seen as recognition of all national constitutional rules. And I agree with this statement. If we look closely, the expression of the law of the European Union and the constitutional identity of the member state is seemingly simple, but in fact very complex issue. The Treaty of Lisbon, which Hungary was the first to ratify, has not managed to resolve it either. In fact, the primacy of the EU law in accordance with the constitutional tradition of the member state is limited in relation to the constitutional identity of the member states, but at the same time, we may have questions about the practical application of the relevant provisions, Article 4.2 of the Treaty of the European Union and the Article 53 of the Charter of the Fundamental Rights. Accordingly, I will discuss both the absolute interpretation of the primacy of EU law and the limits of the interpretation in the next few minutes. I will not be telling you a big secret if I say that the specificity of the EU law is its primacy and its direct scope and autonomy. The question whether there is a hierarchy between supranational law, in particular European law, and national constitution, in particular, and if so, how the different levels should relate to each other. There are different answers, of course. I would like to quote from a resolution adopted by the Parliamentary Assembly of the Council of Europe in 2023. I quote, "The Assembly considers that there is no any hierarchy between the European Court of Human Rights, the Court of Justice of the European Union, and the National Supreme and Constitutional Court, or between the Convention, the European Union law, and national constitution, in the sense of traditional approach to the hierarchy of norms within the constitutional framework. Indeed, any attempt to impose such a hierarchy would be problematic and unhelpful. However, the Assembly considers that there does need to be constructive dialogue between the judicial instances, and that the different jurisdictions do need to respect and acknowledge each other's respective roles, competencies, and sphere of expertise." But the question is simple. As far as the relationship between international law and domestic law is concerned, it is customary to say, following the doctrines of Hans Kelsen and his disciples, that classical international law takes precedence over national law. However, the requirement to enforce EU law in the member state is even higher than that of international law in domestic law, since the existence of new legal order was declared in the case of Van Genden laws. At the beginning of the European construction, the Court of Justice in Costa versus Enel declared the primacy of European law over national law, a primacy which applies over any rule of domestic law. During this period, the primacy of EU law did not affect national constitutions, as the European Court declared the primacy of EU law in the field of economic cooperation. If there were economic cooperation, there was no problem with the constitutions. The precise content of the formula applied in Costa versus Enel was confirmed later by the Court of Justice. In the 1970 International Handelsgesellschaft case, we specified that the primacy also applies to national constitutions. The fact that the member state involves provisions of national law, even if they are constitutional, does not affect the effect of the European Union law on the territory of the state in view of the principle of the primacy of Union law, which is fundamental feature of the Union legal order. The primacy of the EU law over national constitutional law was confirmed by the court in another important case. EU law is also enforced through the principle of loyal cooperation between the countries. Under the principle of loyal cooperation, Article 4.3 of the Treaty of the European Union, member states are also obliged to repeal and not apply national legislation that is not in conformity with EU law. If the situation were to be placed within the framework of classical international law, the Court of Justice would simply establish primacy and leave member states free to draw conclusions for their internal sphere at the risk incurring international legal liability for breach of international norm. But this is not the case for the Union. This freedom of statehood is limited, subject to the duty of loyal cooperation. This duty of loyal cooperation applies to all national authorities, including local and regional authorities, and in particular to the national judge, as is clear from the Cimental judgment. The Court of Justice may therefore even require a national judge not to apply a national law which is found not to be in conformity with the EU law, pending a decision on the substance of the case. The primacy of EU law is also reflected in the margin of the treaties. Declaration 17, annexed to the Lisbon Treaty, recalls the existence of principle, and I quote, according to the settled case law of the Court of Justice of the European Union, Union law and Union law are made under the treaties prevails over national law under conditions laid down by the case law. However, it must be noted that the member states have not sought to incorporate the principle of the primacy of EU law into the treaties, despite the settled and constant jurisprudence of the court. It is not wise to underestimate the silence or reticence. The absence of the codification of the primacy of EU law in the treaties indicates the will of the member state not to want to elevate the principle of primacy of EU law to the level of the treaties. It is all the more interesting to note this absence, as we know that other judgments of the Court of Justice of fundamental importance have been codified in the treaties in some way. It is clear that the case law has given a very wide scope to the primacy of EU law. However, since the supremacy is not provided for in the treaties, it is not an absolute supremacy of application. Its limits are also set out in the treaties, in particular, as I mentioned, Article 4.2 of the Treaty of the European Union and Article 53 of the Charter of the Fundamental Rights. The construction of the primacy of EU law through judicial practice has met with resistance, or if you like, a lukewarm reception in some constitutional court. As regards the primacy of EU law over the French Constitution, the issues were clarified by the French Constitutional Council in the decision of the 10 June 2004 on a law of confidence in the digital economy numérique. According to the Constitutional Council, the obligation to respect EU law derives from the French Constitution. The legislature must respect EU law when transposing a directive. It is not for a Constitutional Council to examine the constitutionality of the transposing legislation unless the Constitution expressly provides otherwise. Only the EU judge can examine whether the directive respects the limits of the Union competence and fundamental rights. The Constitutional Council therefore takes a backseat to EU law, but bases its primacy on the Constitution and not any specificity of the legal order. Later, the French Constitutional Court clearly confirmed that supremacy does not prevail over the French Constitution, and the French Constitution remains at the apex of the internal legal order. The same solution applies in Germany and Italy. The German and Italian constitutional courts, accepting the primacy of EU law over law that does not reach constitutional level, reject it in relation to their constitution, as shown by Solange 1, Solange 2, Solange 3 in 2000, and the Frontini and Frey judgment. In its judgment of the 5th May 2020, the German Constitutional Court, ruling on the constitutional complaint, disagreed with the ECG's interpretation and found that the EU institution, including the ECG, has acted ultra vires. Needless to say, this decision caused a minor earthquake in Brussels. The Commission launched an infringement process against Germany. The German government immediately promised that the next time they would like to avoid this possibility. In 2016 and 2021, the Hungarian Constitutional Court issued important decision on the concept of constitutional self-identity and developed the test to verify the effectiveness of the EU law, especially in the migration cases. There is a longer list of like-minded constitutional courts, including the Czech and Polish ones. In the case of Romania, there have also been a number of small battles between the ECG and the Romanian Constitutional Court. In my opinion, the tensions between the case law of the Court of Justice and that of some constitutional court stems from the uncertain limits of the Union's legal framework. As an indispensable part of the national sovereignty, the Constitution is the close link to the state. A national constitution is both a memoir and project, both a political and legal document, both unique and universal, as notre ami Bertrand Mathieu mentioned in his famous book. It should be noted that the European Union does not have a constitution, despite the fact that the case law would like to consider the treaties as such. Indeed, the treaty was called the Basic Constitution Charter in 1986, case of the Lever versus European Parliament. However, in the early 2000s, there was an attempt at constitutionalization which failed in 2005 as a result of the French and Dutch referenda. Since then, the issue of the EU Constitution has been off the agenda, and conflicts are emerging in a different direction. Instead of the ever closer union of the 1983 Stuttgart Declaration, many now want to see a different direction, emphasizing that, in contrast to the centralizing and federalist ideas of the EU, the other side, in the inescapable sovereignty of the member state, the EU is for the member state and not vice versa. On closer inspection, the treaties themselves do not define themselves as a superior source. According to the treaties, the Union's legitimacy derives from the state and citizens. In other words, it is a union of states and citizens of the member states in which the powers do not derive from the treaties, but are exercised jointly by the member states and codified in the treaty. This joint exercise of powers has not been set in stone forever. The member states are still the master of the treaties and have the ample competence that is to say the possibility of allocating powers when treaties are amended by unanimity. It is easy to understand why there are some tensions. On the one hand, the Court of Justice attaches great importance to the principle of primacy of the EU law and the requirement of uniform application of EU law. It's understandable, as stated in different cases. And on the other hand, member states are in different ways, but still attached to their constitutional identity. Whereas, in Germany, the fundamental rights, the rule of law, the welfare state, and the federal system are part, for example, of the constitutional identity in accordance with the German constitution, the so-called eternity clause. In France, the famous liberté, égalité, fraternité, laïcité, solidarité, and the indivisibility of the country, as well as the protection of the French language, are part of the constitutional identity. The Hungarian fundamental law also comprises the image of the constitutional core. Our fundamental law stipulates that the exercise of EU competencies must be consistent with the fundamental rights and freedom enshrined in the fundamental law and must not restrict the Hungarian inalienable right to determine its territory unity, population, form of government, and the state structure. Since Maastricht, the economic nature of the European integration has been increasingly complemented by cooperation on political basis. Societal questions are on the table. It is very difficult issue, the societal question. The family law, the migration, the foreign policy, and so on. As a result, the member state has developed a fear of sovereignty and have expressed reservation about the political union. There is a growing demand for the court of the member states to have supervisory powers over the exercise of the EU competences in order to prevent ultra vires act and for constitutional identity to be respected in European integration. European integration is necessary. No one can question it. But it cannot become an end in itself. It is not a self-evident, and the current European treaty framework was not intended to create a united European state. The member states are different, our history are different, our sensibilities are also different. During qualified decision-making, the countries that remain in the minority are obliged to accept the decision that may even violate the constitutional self-identity. This is the real problem. The EU faces a time when its fate is going to be decided. Centralizing or subsidiarity, you could say, that is the question. To solve the problem, in my opinion, we need much better involve the national parliaments in the European process. And we have to ameliorate the dialogue between the judges. Jacques Delors, the former president of the European Commission, once compared the European Economic Community and integration to a bicycle, which, if we do not move, we will be thrown off. Some have been more eloquent than that. I read in the Time magazine that the chairman of the Fiat at the time was quoted as saying, in relation to economic cooperation without political integration, that Europe is not yet united. The marriage between the European countries is not yet valid because they have not yet divorced. Well, I would not like to comment on the validity of the marriage between the European countries, but we can say that European integration has made great progress since then. However, many people from many of the founding countries are now making their voice, asking us to put aside this particular bicycle for a moment and stop. It is time for consolidation. So, the key to the story of the European significance lies in the member states. It is important to make European integration tangible and sustainable for member states with their own identities. And so, that the ladies and gentlemen present here do not feel that I have placed an unbearable burden on their shoulders with this turn of phrase, please allow me to say forever in the words of the French playwright Jean Giraudoux. Giraudoux, in his 1935 tragedy, La guerre de Troie n'aurait pas lieu, writes the often quoted sentence, le droit le plus puissant des échos de l'imagination. Jamais poète n'a interprété la nature aussi librement qu'un juriste la réalité. Law is the most powerful of the school of imagination. No poet has ever interpreted nature as freely as the lawyer interprets reality. Thank you very much for your attention.